Thank you so much, kapatid, once again for sharing your time with me. Last week, we talked about Article 20 of the Civil Code in relation to Article 19. We talked about causes of action, no cause of action, and what it means when a party lacks a cause of action. We also talked about the requisites for a case to prosper under Article 20 of the Civil Code. We talked about the difference between injury and damage and what happens when these two things concur. Finally, we also discussed the concept of damnum, absque, injuria, or damage without injury. Just as I've mentioned in our previous lessons, Article 19 of the Civil Code does not exist in a vacuum. It has to be discussed in the context of Articles 20 and 21. In tonight's lesson, we will compare Articles 20 and 21 and correlate them with Article 19 or the principle of abuse of rights. I hope you pay attention, kapatid, because these three articles and Article 36 of the Civil Code are all considered bar matters under the chapter on human relations. For most professors, these are the only things you will need to learn here. At the end of this lesson, you should be able to 1. Distinguish the causes of action under Articles 20 and 21 of the Civil Code. 2. Identify cases where breach of promise to marry becomes an actionable wrong. 3. Enumerate instances where volenti non-fit injuria should apply. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 21 of the Civil Code provides that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. If you are watching this with your copy of the Codal, please open your Codal to Article 20 of the Civil Code, which provides that every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. Sa unang tingin, kapatid, ay meron silang mga pagkakapareho pero meron din naman silang pinagkaiba. Let's take each of the similarities first. Under Articles 20 and 21 of the Civil Code, the law mentions damages. In both provisions, the law makes it clear that the person who causes damage shall be liable to compensate or indemnify the same. That much is very clear. Tignan naman natin ngayon, kapatid, ang dalawang provisions na ito pagdating sa injury at damage. In Article 20 of the Civil Code, the law does not mention injury, but we know from our previous lessons that injury is the illegal invasion of a known legal right. Hindi naman nasasaad ng derechahan sa Article 20 na kailangan ang injury. Alam natin, kapatid, na dapat magkasama ang injury at damage sa Article 20. Ang basis nito ay ang mga decisions ng Supreme Court. At kung aaralin natin ang mga naging desisyon ng Supreme Court, there is an injury when there is an illegal invasion of a known right. An unlawful act or any act that is contrary to law results to an illegal invasion of a legal right. This right can be the right of a private person like you and me, or it can be the right or duty of the state in general. In Article 21 of the Civil Code, the law mentions injury, again the illegal invasion of a known right, and the resulting damage or the loss, hurt, or harm that comes from an injury. This means, kapatid, that for an action to prosper under Article 20 or Article 21, there must be both injury and damage. The Latin phrase for that is damnum et injuria. Curiously, the law also adds the word loss before the conjunctive or. Does this mean that there can be an action for loss under Article 21 without injury or situation of damnum absque injuria? The answer, kapatid, is no. The rule is still damnum et injuria, damage and injury. Both of these must be present in order for the cause of action under Article 21 to prosper. The phrase loss or injury in this provision simply implies the wider, broader, and deeper reach of the law under Article 21. In Article 20 of the Civil Code, the law requires that the injury must come from an unlawful act, meaning there must be at least one specific provision of the law that is violated. At dahil nga may violation, dapat may bayaran. In Article 21 of the Civil Code, the law does not require a violation of the law. All that the law requires is that there must be a legal act, but this legal act must be against morals, good customs, or public policy. This is why an action under Article 21 of the Civil Code is also called an action contra bonus mores, one that is contrary to good morals. Finally, under Article 20, the law specifies that the injury must be the result of a willful act, sinasadya, or negligence, simpleng kapabayaan lamang. However, if we compare that with Article 21 of the Civil Code, the law provides that the injury or loss must come from a willful act. Dapat isang act na sinadya, kapatid, at hindi lang dahil sa kapabayaan. Sa lahat ng discussion under Article 21 of the Civil Code, hindi pwedeng mawala sa usapan ang mga kaso ng breach of promise to marry. Marami sa kanila ay pare-pareho lang naman ang facts. Boy meets girl, girl also likes boy. Boy promises to marry girl. Boy breaks that promise and off to court we go. Ganyan lang ang kanilang mga kwento, and later on towards the end of this discussion, we will summarize the rules of breach of promise to marry as an actionable wrong under Article 21 of the Civil Code. In Tanhangco versus Court of Appeals, the Supreme Court lays down for us the general rule: the breach of promise of marriage is not an actionable wrong. In this case, Apolonio Tanhangco courted Araceli Santos sometime in December 1957. Both of them were consenting adults at that time. Ngayon, kapatid na nga ako si Apolonio, napakakasalan niya si Araceli, and on the strength and basis of this promise, pumayag si Araceli na tsumena sila. They did so regularly such that in 1959, nagbunga ang kanilang pagtatalik. When Araceli became pregnant, she was filled with embarrassment and humiliation. Remember, kapatid, this happened in the late 1950s. This situation was super scandalous at that time, and as a result, Araceli resigned from her job as a secretary. She filed this action for damages and for child support in the amount of 430 pesos per month, and moral and exemplary damages in the sum of 100,000 pesos plus 10,000 pesos as attorney's fees. For his part, Apolonio moved to dismiss the case based on failure to state a cause of action that, given the set of facts alleged by Araceli, it does not amount to any case and that it should be dismissed. Now, the Court of First Instance or CFI. This, kapatid, is the old designation of the regional trial courts. If you see CFI in old cases, the Supreme Court is referring to our regional trial courts. The CFI ruled in favor of Apolonio. Both of them were consenting adults, and as such, the case should be dismissed for failure to state a cause of action. On appeal, the Court of Appeals ruled that the facts of the case amount to an action for damages under Article 21 of the Civil Code. The Court of Appeals ruled that Article 21 of the Code provides that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. The Court of Appeals ordered that the case be remanded back to the CFI to proceed with the case. The issue in this case, kapatid, is whether or not, under the facts and circumstances, Apolonio is liable for damages for the breach of promise to marry. The Supreme Court, speaking through Justice Jose Benedicto Luna Reyes, reminds us of the deliberations of the Code Commission, or the body assigned to draft the new Civil Code. Under Article 21 of the Code, they have contemplated the situation where a person seduces another person based on the breach of the promise to marry. The essential feature is seduction, that in law is more than mere sexual intercourse or a breach of a promise of marriage. It connotes essentially the idea of deceit, enticement, superior power, or abuse of confidence on the part of the seducer to which the woman has yielded. The action for breach of promise to marry is never a reward. Hindi ito pabuya kapatid para sa karupukan ng isang tao na ma-fall na lang ng walang ka-effort. What the law punishes in cases of breach of promise to marry is the seduction. There is no seduction kung pareho niyong ginusto. If it is a product of mutual lust, what the law punishes here is the idea of deceit, enticement, superior power, or abuse of confidence on the part of the seducer to which the woman has yielded, na kung wala ang promise na iyon, hindi naman ibibigay ni Araceli ang hinihingi ni Apolonio. However, in this case, the Supreme Court ruled that there was no seduction. The Supreme Court found enough evidence to warrant mutual desire. In this case, Apolonio and Araceli had sex for more than a year, except for the brief period where Apolonio was out of the country. The Supreme Court concluded that they had sex voluntarily and they did so for more than a year. Kung totoong niloko lang si Araceli, dapat humingi na siya ng fulfillment sa promise na iyon at hindi na pinatagal. The case ends with a short discussion from Justice Reyes that Araceli is free to pursue other remedies for the recognition and support of her child, but the breach of promise to marry without the element of seduction cannot stand. Another classic case under Article 21 of the Civil Code is the case of Pe versus Pe. This is a very short case, kapatid, and I encourage you to read it and volunteer for recitation on this case in the weeks and months ahead. Alfonso Pe worked as a salesman for the La Perla Cigar and Cigarette Factory and was then assigned in Marinduque. Alfonso Pe was a married man, and this piece of information is a very important fact which we will later discuss. He was the adopted son of Pe Beco, who was also related to Cecilio Pe, the father of Lolita Pe. Because of the similarity in last names, he was welcomed to the house of the Pe family and treated as a family member. Alfonso frequently visited Lolita Pe, a single woman, then 24 years old. She worked as a teacher at a local school. Dumadalaw si Alfonso kay Lolita para magpaturo kung paano magdasal ng rosaryo. The two of them eventually fell in love and they exchanged love letters. Now the letters contained not only their love for each other, but to the extent to which they had carried their relationship. This is the Supreme Court's polite euphemism na based on these letters, si Pe at si Pe ay tunay na tsumetsena. Now the rumors of the love affair reached the ears of Cecilio and the rest of the Pe family. They were scandalized of the relationship because Alfonso was treated as a family member and he was, wait for it, a married man at that. Lolita Pe was made to stay away from Marinduque and she was moved to Quezon City. On April 14, 1957, Lolita left the house of her brothers and sisters, never to return. Her aparador was empty except for a love note from Alfonso asking to meet on a Monday, April 14. The Pe family headed by Cecilio filed a suit under Article 21 of the Civil Code. It would appear, kapatid, that they have a strong case. They alleged Alfonso willfully made Lolita fall in love despite him being a married man, and this has caused great shame and embarrassment on the family. The trial court ruled in favor of Alfonso Pe. It concluded that there was simply not enough evidence to hold Alfonso liable. The lower court ruled that it's very possible that Lolita fell in love with Alfonso against her better judgment, fully aware that Alfonso was a married man. The Supreme Court ruled that the circumstances under which defendant tried to win Lolita's affection cannot lead to any other conclusion than it was he who, through an ingenious scheme or trickery, seduced the latter to the extent of making her fall in love with him. This is shown by the fact that defendant frequented the house of Lolita on the pretext that he wanted her to teach him how to pray the rosary. No other conclusion can be drawn from this chain of events than that defendant not only deliberately but through a clever strategy succeeded in winning the affection and love of Lolita to the extent of having illicit relations with her. The wrong he has caused her and her family is indeed immeasurable, considering the fact that he is a married man. Verily, he has committed an injury to Lolita's family in a manner contrary to morals, good customs, and public policy, as contemplated in Article 21 of the new Civil Code. Note kapatid that in this case, the Supreme Court extends the right to recover damages not only on the part of the woman but also on the part of the family. In Pe versus Pe, the NBI were not able to locate Lolita Pe. It's entirely possible na nagsama nga sina Alfonso at Lolita at sila nga ay nakapagsimula muli sa isang malayong lugar kung saan walang nakakakilala sa kanila. One more case that's going to be important under this topic is Gashem Baksh versus Court of Appeals. Don't worry if you did not get the citation kapatid, there will be a link to the case in the description down below. On October 27, 1987, Marilu Gonzalez came to court to file an action for damages against Gashem Baksh on the basis of the breach of promise to marry. Sinabi ni Malu na siya ay 22 years old at that time, may kagandahan at ginagalang sa kanilang komunidad. Si Gashem naman ay isang Iranian national at nag-aaral ng medisina sa Lyceum Northwestern Colleges sa Dagupan City. Niligawan daw siya ni Gashem, sabi niya, at nangako na magpapakasal sila sa semestral break ng taong ding yon. Dumating ang sem break at nagpunta ang dalawa sa pamilya ni Marilu para magpaalam. Sa statement ni Marilu, virgin siya bago sila nagsama ni Gashem, bago siya nakapag-file ng complaint. Inilahad niyang itinali siya ni Gashem sa kama nila sa kanilang apartment at hindi pinapalabas at pinapainom ng gamot na pampatulog. Sa part naman ni Gashem, sinabi niya na hindi niya pinangakuan ng kasal si Marilu, na siya ay kasal na sa isang babae sa Bacolod City. Itinanggi rin niyang sinaktan niya si Marilu. Sinabi niya na hindi niya pinangakuan ng kasal si Marilu dahil siya ay isang high school graduate lamang, na waitress lang siya sa isang kainan sa Dagupan at ang tatay niya ay nagtatricycle lang. Muslim si Gashem, sabi niya, at foreigner siya. Dagdag pa niya at dahil dito hindi siya aware sa mga customs sa Christian or Catholic faith o good morals ng mga Pilipino. The lower court ruled in favor of Marilu on the strength of Article 21 of the Civil Code. It concluded that Marilu would not have given herself had it not been for the promise of marriage made by Gashem. That Gashem deflowered her and that Gashem violated Filipino customs and morals by turning back on the promise of marriage, kahit pa may preparations na ring nagawa ang pamilya ni Marilu. The Supreme Court in this case reiterated the general rule that the breach of promise to marry is not an actionable wrong. However, in the light of the above laudable purpose of Article 21, we are of the opinion and so hold that where a man's promise to marry is in fact the proximate cause of the acceptance of his love by a woman and his representation to fulfill that promise thereafter becomes the proximate cause of the giving of herself unto him in a sexual congress, proof that he had in reality no intention of marrying her and that the promise was only a subtle scheme or deceptive device to entice or inveigle her to accept him and to obtain her consent to the sexual act, could justify the award of damages pursuant to Article 21, not because of such promise to marry but because of the fraud and deceit behind it and the willful injury to her honor and reputation which followed thereafter. It is essential, however, that such injury should have been committed in a manner contrary to morals, good customs, or public policy. The statements made by Gashem revealed his true intention for Marilu. It is clear that he harbors a condescending if not sarcastic regard for the private respondent on account of the latter's ignoble birth, inferior educational background, poverty, and as perceived by him, dishonorable employment. Obviously, then, from the very beginning, he was not at all moved by good faith and an honest motive. Marrying with a woman with such circumstances could not have even remotely occurred to him. Thus, his profession of love and promise to marry were empty words directly intended to fool, dupe, entice, beguile, and deceive the poor woman into believing that indeed he loved her and would want her to be his life's partner. His was nothing but pure lust which he wanted satisfied by a Filipino Filipina who honestly believed that by accepting his proffer of love and proposal of marriage, she would be able to enjoy a life of ease and security. Gashem tried one more argument, and this is the argument of pari delicto. This is a rule that states that if both parties are wrong, the courts will leave them in substantially the same condition. No relief can be had or can be given. The premise of the rule is that he who comes to court must come to court with clean hands. Kung pareho kayong mali, tinatrato na lang kapatid ng batas na tabla kayo. Each of the parties must bear their own losses. To this, the Supreme Court ruled that the pari delicto rule does not apply in this case, for while indeed the private respondent may not have been impelled by the purest of intentions, she eventually submitted to the petitioner in sexual congress not out of lust but because of moral seduction. In fact, it is apparent that she had qualms of conscience about the entire episode, for as soon as she found out that the petitioner was not going to marry her after all, she left him. She is not therefore in pari delicto with the petitioner. Pari delicto means in equal fault in a similar offense or crime, equal in guilt or in legal fault. At most, it must be considered that she is merely in delicto. Another important case when it comes to the breach of promise to marry is the case of Wasmer versus Velez. In this case, following their mutual love for each other, Beatriz Wasmer and Francisco Velez decided to get married on September 4, 1957. All of the preparations for the wedding were made. Beatriz had a wedding gown made, dresses for the entourage, maid of honor, and flower girl. Invitations were given out and they also had bridal showers. Gifts were received. However, 2 days before the wedding, Francisco left a note to his bride-to-be saying that the wedding has to be postponed because his mother opposes it. Thereafter, Francisco boarded a plane to Mindanao. The next day, he sent a telegram stating nothing has changed and he apologizes to the parents of Beatriz and that he will be returning soon. Thereafter, he was never heard from again. The issue in this case was whether or not Francisco Velez should be liable for damages for his breach of promise to marry. The Supreme Court ruled that this is not a case of mere breach of promise to marry. As stated, mere breach of promise to marry is not an actionable wrong, but to formally set a wedding and go through all the above described preparation and publicity only to walk out of it when the matrimony is about to be solemnized is quite different. This is palpably and unjustifiably contrary to good customs for which defendant must be held answerable in damages in accordance with Article 21 aforesaid. When we look at the leading cases in breach of promise to marry, and I do hope kapatid that you take note of this dahil ito ang mga pinaka-common na tanong sa midterms para sa persons. The general rule is that the breach of promise to marry is not an actionable wrong. The exceptions are one, when there is seduction or the man employs deceit, enticement, superior power, or abuse of confidence on the part of the seducer to which the woman has yielded. 2. When the promise of marriage is the proximate cause of why a woman would have sex with a man and the man clearly has no intention to fulfill this promise. 3. When there have been extensive preparations for the wedding and one of the parties walks out when the matrimony is about to be solemnized. At katulad ng ating mga unang nabanggit kapatid, ang mga aksyon sa ilalim ng Article 21 ay hindi lang limitado sa babaeng iniwan o pinangakuan ng kasal. The action for damages is also available on behalf of the family who suffers embarrassment as a result of the willful act that is contrary to morals, good customs, and public policy. There are other actions under Article 21 and it is wrong to assume that they involve only breaches of promises to marry. One such case is the case of Roberto Reyes, also known as Amay Bisaya. He is an actor kapatid and I remember him best for his parts in the recent remake of the movie Hari ng Tondo. Alam ko kapatid, curious ka na kung sino siya. Pause mo muna ito at silipin mo sa Google kung sino nga si Amay Bisaya so you can better appreciate the case he filed. Sometime in 1994, Amay Bisaya or Roberto Reyes was having coffee in the hotel lobby of the Nico Hotel na ngayon ay Dusit Tani kung hindi ako nagkakamali. While he was enjoying a cup of coffee, he spotted a friend, Dr. Violeta Filart, who was on her way to a birthday party for the manager of the hotel. He claims he was invited by Dr. Filart and the two of them went up to the hotel's penthouse with Reyes carrying a basket of fruits for Dr. Filart. He also asked if Dr. Filart could vouch for him at the party. She He said yes. When the buffet dinner was about to be served, Amay Bisaya went up and queued to be served. There he was approached by a certain Ruby Lim who claimed to be the executive secretary of the hotel. According to the version of the plaintiff, Amay Bisaya, Ruby Lim approached and in a loud voice told him, "Huwag ka nang kumain, hindi ka imbitado, bumaba ka na lang." Amay Bisaya tried to explain that he was there as a guest of Dr. Filart. Lim allegedly completely ignored her. Thereafter, he was escorted out of the hotel by an officer of the Makati City Police. This embarrassing and traumatic incident prompted Amay Bisaya to file the complaint for damages amounting to a total of 2.2 million pesos. For her part, Miss Ruby Lim admits to asking Amay Bisaya to leave the party but not under the circumstances he narrated. She claims that she has been the executive secretary for the past 20 years. Part of her job is organizing parties such as these, and for the birthday of the hotel's former general manager, she generated a short list of friends and co-workers. Mr. Roberto Reyes, Amay Bisaya, was not among them. Further, she claims to have spoken to several staff and guests during the party to inquire as to the presence of Amay Bisaya. She requested staff and guests to ask Amay Bisaya to leave. When the latter lingered and refused to leave, she approached him and said, "Alam ninyo, hindi ho kayo dapat nandito. Pero total, nakakuha na ho kayo ng pagkain, ubusin nyo na lang ho yan. At pagkatapos kung pwede lang po, umalis na kayo." In the version of Miss Lim, this was the point of our story. When Amay Bisaya started to make a big scene and even threatened to dump food on Miss Lim. For the version of Dr. Violeta Filart, she denied inviting Amay Bisaya to the party. It was in fact the actor Dr. Filart claims who volunteered to carry the fruits up the penthouse because he was taking the same elevator. She reminded him to alight from the elevator because 1, he was not invited, and 2, he was not dressed for the party. The trial court ruled in favor of Miss Lim and the hotel, declaring that the plaintiff had no business being in the party. Sabi ng korte, alam ni Amay Bisaya na hindi yun party ni Dr. Filart. At kahit totoong inimbitahan siya ni Dr. Filart ay hindi naman din dapat maging responsibilidad ng doktor ang pag-gate crash ni Amay Bisaya. On appeal, the Court of Appeals ruled in favor of Amay Bisaya. It found Miss Lim and the hotel liable for the way they have treated the actor. The Court of Appeals further ruled that Miss Lim's act of approaching other staff and guests added to the embarrassment and ridicule suffered by the plaintiff, and thus the plaintiff should be entitled to the damages claimed. And because it was the doctor who invited the plaintiff, she must also be held liable for damages along with Miss Lim and the hotel, because were it not for her invitation, the actor would not have suffered such great embarrassment. In this case, the Supreme Court lays down for us the requisites for an action contra bonus mores. The court teaches us that for an action under Article 21 to prosper, there must be 1. There is a legal act. 2. The act is contrary to morals, good customs, public order, and public policy. 3. The act is done with intent to injure. In this case, the court ruled that Miss Ruby Lim had every right to ask the plaintiff to leave. Trabaho ni Miss Lim ang magpaparty ng ganito. Kung kailangan pa niyang i-report ito sa boss niya o kung magkakaroon ng eskandalo sa party, it will reflect badly on Miss Lim. So she did it as discreetly and as quietly as possible. The court also found no intention to injure on the part of Miss Lim. Bago pa man ang party na ito, hindi magkakilala si Miss Lim at si Amay Bisaya. Kahit nasabihin ni Amay na si Lim ay matandang dalaga at matapobre, wala itong naging basihan sa records ng kaso. Dahil kulang ang requisites, hindi pwedeng mabigyan ng danyo si Amay Bisaya. Hindi liable si Miss Lim, si Dr. Filart at ang hotel sa kanya. Any injury suffered by Amay Bisaya must be borne by him alone. In this case, the Supreme Court also wants us to learn about the concept of volenti non-fit injuria. This phrase means to which a person assents is not esteemed in law as injury. This phrase also means self-inflicted injury or consent to injury. What this means, kapatid, is that any person who voluntarily exposes himself to injury, even if he is negligent in doing so, cannot recover damages. Mayroong lumang kaso ang Supreme Court. It's over 100 years old. It's the case of Cerezo versus the Atlantic Gulf and Pacific Company, kung saan may mga trabahador na naghuhukay ng mga kanal sa Maynila. Isang linggo na ang hukay na ito at hindi naman ito kalaliman. Mga 3 to 4 feet lang ang lalim. Ang kanal na ito ay medyo matibay, siksik ang lupa at hindi naman kinailangan ng braces. May isang manggagawa na doon inabot ng sakit ng tiyan. Wala na siguro siyang magawa, kaya nag-squat na siya sa kanal at doon na siya dumumi. For whatever reason, gumuho ang kanal at siya ay natabunan pero hanggang leeg lang. Namatay ang empleyado at naghabol ng damages ang nanay niya. In this case, the Supreme Court applied the principle of volenti non-fit injuria. Kusang pumasok sa kanal ang trabahador, doon siya dumumi. Gumuho ang kanal. By squatting and pooping inside the trench, he has voluntarily exposed himself to risk and injury. Even if he was negligent, even if it was to answer a call of nature, he went inside the trench on his own. Thus, for his own injury, no other person can be liable for damages. To summarize tonight's lesson, number 1, a case under Article 21 will only prosper when there is a legal act, but which is contrary to morals, good customs, public order, and public policy. And this act is done with intent to injure. 2. Article 20 stems from an unlawful act and it can be done willfully or negligently, while Article 21 is based on an act that is contra bonus mores and can only be committed willfully. 3. A breach of promise to marry is not an actionable wrong except when there is seduction, when the promise is the proximate cause for sexual intercourse and there is no intention to keep that promise. And finally, when preparations for the wedding have been made. 4. Volenti non-fit injuria is a doctrine that bars the recovery of damages when the injured person voluntarily exposes himself to risk or injury, even if he was negligent in doing so. Tonight's lesson is a very long lesson, kapatid. Hinabaan ko ito para matikman mo naman kung ano ang posibleng feeling ng mahahabang lecture sa law school. Please let me know if you like this format or if you found this boring at inantok ka na. All of the cases I have discussed I will link in the description down below. I hope you read them on your own. Walang lumulusot sa persons, kapatid, nang hindi nababasa ang mga kasong ito. If you would like us to continue with Article 22 next week, please let me know by typing yes in the comments down below. Finally, there is a quiz, and this is a long quiz to test your understanding not only of this lesson but the previous lessons as well. Please do not discuss the quiz in the comments down below so as not to spoil the quiz for those who will watch later. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.